And so you'll talk to me, not to
Okay.
the camera, please. Okay. So thank you so much for doing this. This is really wonderful.
My
It's so
pleasure.
important. So could you just begin by saying your name and how you'd like to be identified in the film?
Sure. I'm Brian Kammer. I was counsel for Warrenley Hill for approximately 19 years. Is that right? 1996 to 2015. So 19 years.
And you're currently?
I am currently the director of the habeas project at the Mercer University School of Law.
Okay.
Do you need me to do that again?
Yes, that'd be good.
I am currently the director of the habeas project at the Mercer University School of Law.
And I've been to Mercer itself. That's in Macon, right?
That is correct.
Is the law school there
Mhm.
as well? Okay, that was just for me. Okay. Can you describe what Warren was like as a person? I'll just start with Warren.
Warren was an African American man that I met when I was about 26 years old. He had been convicted of the murder of a fellow prisoner and sentenced to death in the early 90s in Lee County, Georgia. He had an intellectual disability. He had an IQ of about 70, and so he had impairments that are associated with that level of functioning. He was someone who had, for whom it was difficult to express emotions, it was difficult to express feelings, it was difficult to express complex thoughts. So, the conversations could be very basic with him, and he was a very quiet person. But as our relationship developed, I would say that we became very close. He was definitely someone who could reflect on his life and could reflect on why he was in prison and to feel deep remorse about that. He did not always understand the legal proceedings that were going on in his case, but I think that he knew that I and others were fighting for him, and I think that was a source of some solace to him. He had a very close relationship with his family members, his mother and his sisters and his brothers, and he saw them fairly regularly, and I think that gave him a sense of security and love that was important for his ability to survive the many, many years that he served on death row.
And you said that he was very quiet.
He was very quiet.
And what was it like to be in his presence and interact with him? Not so much the cognitive, which you explained really clearly, but kind of personality.
He was very friendly to me. We had a very friendly relationship. In a way, we weren't that different age-wise. He was a bit older than me, so there was a sense in which we were growing into our middle age together. And as we got to know each other better, it was I would even venture to say there was a familial kind of feeling between us.
Can you talk about, in your own interactions with him, what was the most angry, aggressive, violent he ever got?
I never saw any of that with Warren. Warren was always calm, friendly, polite. His affect was not one of animation, but it was never aggressive or violent or anything approaching that. I never saw him express any anger. He did his time, and he was not demanding at all of me or any of the other staff, attorneys, or investigators who worked on his case. He had a lot of trust in us, and he never showed any kind of flashes of anger or aggressiveness.
Joe,
Yes.
you'll let me know, are the cars going by?
There's nothing you can do about it, so may as well just accept
It's
it as
good.
background noise.
Okay, that's fine. Can you talk about Warren's life history?
Sure. Warren grew up he moved around a good bit as a child. His family was in near poverty or outright poverty during much of his childhood. He had several sisters and brothers. They moved around, in the vicinity of northeast Georgia and into the area of South Carolina that sort of borders that part of Georgia, Anderson, South Carolina. Mr. Warren's father was abusive to his mother and to not as much to the kids, but to his mother, extremely abusive, violent. And his mother would often, leave the home with the kids, go to a relative's home. The whole family was moving around a lot. Because of that and because of economic instability, and so it was very chaotic. There were accounts of Warren's mother fleeing her husband and hiding in the bushes around the house. Warren would try to intervene in fights and protect his mother. He had a seizure disorder from a very young age. He suffered from a severe fever when he was an infant, and this probably engendered the seizure disorder or exacerbated a tendency towards a seizure disorder. And so he had tended to have seizures quite a bit. The chaos in his upbringing, I think, exacerbated that problem. And of course, he also had an intellectual disability from birth, essentially. And you never know what the causes are for that, but it could have been any number of insults to the developing brain in utero or in the impoverished circumstances of his infancy. But in any event, in fact, the seizures themselves may have contributed to the disability as well. So he was held back repeatedly in elementary school. Teachers noted early on that he had cognitive impairment, that he could not keep up with other students. He would fail all of his classes, but teachers in those early years would often inflate, grades in order to get him to move up the ladder into the next grade, in order to keep him kind of parallel with some of his peers at least. But I talked to several of his teachers and all were unanimous that he, had significant cognitive impairment. He there was something else I wanted to add to that. But he would often be picked on by peers for being slow. There were some family members who also kind of made him aware that he was slow, so to speak. His sisters did their best to help him with homework, and he was developmentally delayed in terms of his ability to kind of dress himself or control bodily functions. His sisters especially kind of helped him navigate all of those things, helped him through school by doing his homework, that sort of thing. He eventually was able to graduate from high school, and then he joined the Navy, where he went to Boston initially after he joined the Navy, and it seems that it was recognized that he had impairments. He could never advance beyond a certain low rank in the Navy. He benefited from the structure that he found there, and was able to be satisfactory in sort of following basic orders and, following the routines up to a certain point. When he transferred back to the Naval Air Station up here in Marietta, back in, I want to say, late 70s, early 80s, the problem was that they did not recognize, they didn't know him, and they didn't understand that he had a disability, or that he was slow, so to speak. And as a result, he began to be assigned tasks and responsibilities that were too difficult, and he kind of decompensated at that time. I can keep going on, or you might want to break it up a little bit with some questions, perhaps.
That's great.
Okay.
I just want to go back to a few things. Well, could you say what you mean by he decompensated?
Well, in Boston, he was working with people who had gotten to know him and gotten to know his limits. They helped him not succumb to his weaknesses. People with intellectual disability have the low IQ, the low intellectual functioning, or limited intellectual functioning. And as a consequence of that, they also have deficits in their coping skills. That can mean anything from being able to take care of themselves, live independently, seek help when there are challenges or problems, do basic things like have a bank account, or the basic tasks of living, and those limitations can cause problems when life's challenges get too complex or overwhelming, and that can cause someone to kind of fall apart functionally. When he was transferred to Marietta, he was sort of expected to perform at a level that he was not able to.
I'm going to interrupt you. There's a big car going by.
Sure.
He transferred to Marietta.
Transferred to Marietta, and sure.
When he transferred, it happened.
Yep. When he transferred to Marietta, he was given tasks that were at a level that was too challenging for him, and he began to decompensate in his performance. He was in a he had gotten into a relationship, and it was all relationships can be challenging. For someone with an intellectual disability, they can be extremely challenging, and that combined with the excessive responsibilities that he was being given in the new setting was frankly too much for him. When he ended his relationship, he found himself having to live alone, and that was probably the first time that he had ever lived on his own, and he could not handle that. His sisters would find him in his bed, covered with blankets, not speaking, those kinds of things. The family, did their best to sort of take care of him at that point, but he was ultimately, that phase of his life ended when he took the life of his ex-girlfriend. And that was why he was in prison when the homicide of the fellow prisoner occurred. The trajectory of his time in prison is important, because when he was initially convicted of the homicide, and in my opinion, that the homicide of his former girlfriend was a product of his mental decompensation at that time. He was completely overmatched in his ability to navigate life. When he was imprisoned for the murder, he was initially classified as a high-security inmate. That classification, which is automatic for anyone convicted of a homicide, was helpful to him because it imposed a strict routine and a structure on his life that he could work with. I believe he was initially housed in a single cell or with one other inmate, and otherwise, his movements were strictly monitored and controlled. Every event of his day was planned out. He was told where to go and what to do, and like the military, it was a structure that he, as a person with an intellectual disability, could adjust to, or rather, that setting adjusted to him, adjusted to his particular profile. Because he did well in that setting, the security classification was sort of diminished or reset to a more flexible medium security setting, and then finally to a minimum security setting, I believe, where he was housed in a dormitory with other prisoners. The records of his time in the prison there at the Lee County Correctional Facility are very clear that counselors at the prison were deeply concerned, especially after he was moved into this dormitory setting. They were very concerned that he was having problems, that he was vulnerable to manipulation and victimization by other prisoners. They recognized that he had some kind of cognitive impairment. They recognized that he had extreme difficulty expressing himself and expressing that he may be having problems. He had a lot of difficulty reaching out to counselors, for example, for help in dealing with the relative chaos of the dormitory setting. There was one prisoner in particular who was harassing him and making his life difficult. And of course, that happens in prison. You have to deal with aggressive fellow inmates. The way you deal with that is you reach out to staff and counselors at the prison. And in fact, he did try to get his bunk moved so that he could be farther away from the prisoner. But the harassment continued, and that was witnessed by many of the other prisoners in the dormitory. And that prisoner had a history of homicide and mental disorders as well, as I learned in my investigation. And what happened was that essentially was the context for Warren committing the homicide against that prisoner. When he was then put on trial for that, he was prosecuted by a very ambitious prosecutor who was looking for a judgeship, and therefore, that was part of the motivator to seek capital punishment for him. I think it was the first capital prosecution in Lee County, Georgia, in decades. At that time, there was no statewide capital public defender system in Georgia. So the default was to appoint attorneys from the community who were willing to take the case. So in this case, 2 attorneys were appointed who were, solo practitioners, essentially, in the community. They had some experience doing criminal defense, but they were sort of your all-purpose solo practitioner attorneys. They were not necessarily highly trained capital defenders that today would be assigned to represent anyone charged with a capital murder. So that, combined with the lack of resources that were provided to the attorneys at that time, resources were doled out by the counties, by the county systems. So the trial judge, had to husband the resources of the county in doling out funds for example, experts or investigative assistants. Today, those monies are within the budget of the Capital Public Defender Office, and so there's vastly more resources appointed for capital cases, because there's been a recognition that, since the mid-2000s, that these cases require hefty influxes of resources to create fairness in the process. But that wasn't the case in the early 90s when Warren was tried. And so, for example, the trial court would not allow the attorneys to, personally journey to northeast Georgia to interview teachers, for example, or to seek records in person. They had to essentially find witnesses and request documents and things by phone or by mail. And they did that. They tried to do that. But that approach tends to, it tends to result in things getting missed. So, for example, when the attorneys wrote to Warren's elementary schools and junior high schools for school records, they did so by mail, and they got responses through the mail of Xeroxed records. Those records didn't have any test scores, but they were represented to be the entire school files. And so at trial, when the school records were presented, and when arguments were made about Warren's limited intellectual functioning, jurors expressed confusion that there were no test scores in the school records. And there was a sense that the defense was hiding those scores. And that was gleaned from post-trial juror interviews. But we found when my office took Warren's case after he had been sentenced to death, we reinvestigated the case. We physically went to the schools and asked them to look in their files on the spot for those records. And what we determined, and this is just one example, is that some of the records had been double-sided copies, but only one side had been copied to the attorneys, and the sides that were not copied contained the test scores, which showed that he was testing in the impaired range, consistent with an intellectual disability. So that's just one example of the way the initial trial team was handicapped in their ability to adequately represent Warren. And really for that reason, the psychologist that they employed at the time of the trial was unable to render a diagnosis. He had, in fact, I think testified at the trial that he wondered where the test scores were, because schools always test. So this just generated a sense of doubt about the reality of Warren's intellectual limitations.
Great. Okay, so I want to go, I got a whole bunch of questions based on what you said. Could you, back to his childhood, could you talk about, I read the mitigation material. Could you talk about how there was often no food in the house and why, and the father's alcoholism?
That's right.
And that they often had no heat in cold weather, and let's just start with that.
Okay. One of the challenges the family faced was the father's alcoholism, which would often result in the father using his paycheck to pay for alcohol rather than food, and the kids would go hungry. There were family members who tried to help out, but again, this was a family that was the extended family was not in good shape economically. So that wasn't enough all the time. So the chaos of the home, where Warren and his siblings would have to cope with bouts of violence by their father, bouts of drunkenness, and in fact, Warren's mother was also a source of abuse to him. Warren's mother was beloved in the family, but she was someone who also probably suffered from an intellectual disability. And so her coping skills were limited as well. And my impression was that she would often take out her frustrations on Warren. And she would often rationalize her abuse of Warren by the fact that he was quote-unquote slow. So there was that dynamic as well. It was a kind of a vicious cycle of intergenerational abuse and trauma. Warren was beaten regularly with a variety of implements, really anything that was at hand. And, that is, and he was, that could trigger seizures. Any of these sort of episodes of violence and chaos could trigger a seizure. One can only imagine what it was like for Warren as a child growing up in this environment. He survived extensive trauma. He grew up at a time when there really weren't services, for example, in the schools, to deal with special needs children, to provide them with services, to provide them with psychological evaluation. He actually was attending the last vestiges of segregated schools in Georgia, and they didn't have the special education programs that emerged later on, so he didn't get the benefit of those kinds of programs, and much less any programs to help identify abuse in the home, other problems affecting the children. He was just kind of too early in time for those things to have been available, and so he was not getting any help in learning to regulate his emotions or to help him express how he might be feeling. He just didn't get any of that. So his sisters were kind of the bulwark for him, and he in turn was a protector of his younger siblings, and they, even as they tried to take care of him, they also looked up to him. When he was in the Navy, he would send them packs of underwear and tried to provide for them as best he knew how. But really, the siblings, especially his sisters, ended up helping him do things like manage his money and ultimately, take care of him when he couldn't live by himself.
Can I just stop a second?
Yes.
I need to make
The 10 kids, no food, and the cold.
Okay. Warren was one of 10 children. Again, this was an extremely impoverished family. The father was drinking away money for food. If there was food, the father would often consume it before the kids had a chance. Warren's mother would frequently call on her sisters to bring food, but again, they too were not in the best economic straits, so it was difficult for all involved, obviously. They were food insecure for much of Warren's childhood. In the wintertime in northeast Georgia, it gets very cold. It gets below freezing regularly, and the home often didn't have heat. So there were these chronic consequences of living in poverty for the family.
Great. And can you just say, you almost said it a few minutes ago, that he never had an IQ test, right?
He did have some testing in school, but he didn't have. He had the they were not formal IQ tests. They were the kinds of tests that are typically or were typically given to elementary level children. But those tests correlated with significantly impaired functioning. So if you were to look, for example, on the in junior high school, they had Warren and his classmates take, I believe, the Otis Alpha test, or one of those sort of tests of academic achievement. He performed in the second or third percentile, which is the functional equivalent of an IQ of about 70. It correlates with that level of functioning. And one of in Georgia, since 1988, the law has protected defendants with intellectual disability from execution. The General Assembly passed a law in that year, 1988, that exempted people with intellectual disability from capital punishment. But the burden of proof for folks claiming to have an intellectual disability is that they had to prove it beyond a reasonable doubt, which is the heaviest burden of proof in the law. And so when you are faced with the burden of proving an intellectual disability beyond a reasonable doubt, and you don't have evidence of, like documented deficits from the early developmental period in the defendant's life, you're really facing an insurmountable barrier to proving that you have intellectual disability. So that's sort of where that was the dilemma for Warren Hill all through the decades of litigation. Initially, the trial team didn't have the resources to assemble the kind of evidence that could have allowed for a robust defense centered on intellectual disability, as we've talked about. He was convicted and sentenced to death, and his case then came within the ambit of my office, the Georgia Resource Center at that time, which specialized in post-conviction appeals. The problem when you have not been able to raise an issue or presented facts at the trial stage is that you face severe legal hurdles to getting those facts, if you can later find them or develop them, get them considered by a court. So when you're in the post-conviction context, which is where my office would get a case like Warren's, we would conduct a robust investigation of the case at that point, which we did in Warren's case. We were able to uncover a massive amount of mitigating evidence, as we've discussed, regarding his home life and upbringing, as well as ample evidence of his intellectual disability, including the test scores that were not discovered at the time of trial. We were able to get him finally tested in a robust way so that we could really clearly point to concrete evidence of intellectual disability. That evidence probably would have, or certainly it is more than plausible that a jury hearing that evidence at the trial stage may have sentenced him to life. But when my office, when I got the case, our goal was to show our court that this new evidence justified overturning the death sentence and giving him a new shot, a new sentencing trial. That is, at that point, the burden is on Warren to prove that he should get that second chance. And it's very difficult to prove that.
Could you address the fact that that because the accepted definitions of intellectual disability say he has to have had it before he was 18, and he didn't have an IQ test before he was 18.
Right.
So could you address that?
So the definition of intellectual disability is that you have an IQ of approximately 70, that there are accompanying that low, what is described as a significantly sub-average level of intellectual functioning. You have associated with that what are called adaptive deficits, which are deficits in adaptive skills, coping skills, your ability to adapt to any number of life's challenges. And they've been kind of categorized over the years as encompassing things like home living, self-care, ability to engage in leisure activities, ability to do functional academics, those kinds of things. And in other words, the practical skills you need to navigate an independent living. And the bottom line question is, can this person live independently without any supports? And that, along the lines I've just discussed. And he has to, the person has to have manifested those deficits and that low level of intellectual functioning in the developmental period prior to age 18. So if you have a normal average IQ with normal levels of adaptive skills, coping skills, when you are 18 and you get hit on the head or you have a trauma that causes you to lose brain functioning, you may be, functionally speaking, intellectually have an intellectual disability, but you wouldn't qualify for the diagnosis because it happened when you were 18, if that makes sense. So you've got to prove, it's not just a matter of proving an IQ score, it is far more than that, a matter of proving a whole pattern of deficits in coping skills that reach back to childhood. And that's not easy to prove in the first place. Most jurisdictions in this country require defendants claiming intellectual disability in the capital context to do so by a preponderance of the evidence, which is often articulated otherwise as the 51% rule. If the evidence sort of shows about within 51% that there is the diagnosis is warranted, you can be credited with having the diagnosis. But not in Georgia. You've got to prove it beyond a reasonable doubt. So if there's a gap in the evidence, even a tiny gap, that can be construed as a reasonable doubt. So that has been the challenge facing Warren Hill ever since his trial.
And could you just say that a simple sentence about he had never had an IQ test before he
Correct.
turned 18?
So, right, Warren Hill had never had an IQ test, a what is called a individually administered standardized test of intellectual functioning, such as the Wechsler Adult Intelligence Scale or the Stanford-Binet, administered to him prior to his being on trial. And so the very lack of that test was cited as a lack of evidence that he a lack of evidence for intellectual disability, which would have protected him from execution. He, at the trial, as I've discussed, he, you can substitute for a lack of one of these sort of gold standard IQ tests by pointing to other kinds of testing that may have been performed in that age prior to 18. But you also can point to evidence of the adaptive skills in the form of recollections of family members, teachers, other people who had contact with the defendant in that time period. And so that's what we did in Warren's case. We were able to obtain testimony from family members that he couldn't manage money. He couldn't do his homework without substantial assistance by siblings who would even do it for him. And so, for example, by the time of high school, it may have looked like he had gotten through high school with a C or D average, but what was really happening was he was being assisted throughout by his sisters. Those are difficult. It is difficult to, again, it just points up the difficulty of proving intellectual deficits through a client's history. But the totality of the data, clearly pointed to a continuous deficit since infancy, essentially. The problem with proving intellectual disability where the defendant is right on the cusp, which is that IQ level of about 70, is that anything to the contrary or seemingly to the contrary of a diagnosis of intellectual disability can tip the balance a little bit, so that a decision maker could say, well, I have a doubt that this person has intellectual disability. Especially in Georgia, the burden of proof makes that problem of diagnosis or fact finding even more difficult.
So great, fabulous. I want to go back to his childhood for 3 more things. You had said he was a loner. Could you address in his, correct me if I'm wrong, everything I read about him suggested that he'd never done anything aggressive or violent except for those 2 murders. So if you could address that like from the time
right.
he was a kid, and the 2 things that just broke my heart, if you could mention. One is when he got the grocery store job that he only brought groceries home for the family, didn't keep the money for himself, and the milk and cookies story.
You have to remind me of the milk and cookies story.
When he was a little kid and would get milk and cookies at school, he'd save it and bring it home for the family because they didn't have any.
Did you read that in the affidavits? Okay, good. I'll repeat that.
If you're comfortable.
Sure, yeah.
So the absolute lack of any violence.
Sure.
Except the tumor.
Yeah. So Warren Hill, from the time he was a child, was, never showed signs of aggression or violence. He tried to stop violence between his parents, for example. He was not particularly social in any event. He was quiet and kept to himself because that was what was comfortable for him, and that was the same eventually when he was imprisoned. The only known episodes of violence were the 2 homicides for which he was convicted. Warren would some of the stories are heartbreaking. For example, and they are totally consistent with intellectual disability. For example, as a 12 and 13-year-old, I believe he worked at a local convenience store where, very frankly, the owners took advantage of him, paying him pennies paying him virtually nothing in terms of money, but allowing him to bring food home sometimes to his family, but essentially working him for nothing. Any money that he did, actual cash money that he would bring home, his mother would take. One of the other stories about Warren's love for his family had to do with coming home from school, having saved, not eaten or consumed milk and cookies that he would receive at school so that the family could share them. So Warren was always trying to provide as best he could for his family, while just coping as best he could. So Warren's intellectual disability certainly did not diminish his ability to show love and affection for his family. And that continued up until the day he died.
Okay. When he,
Just gonna make a quick adjustment here. Go ahead, you can,
well, I want to ask you to talk about what happened when he killed his girlfriend. Did they read him the Miranda rights? Was a lawyer present when he was interrogated? Did he sign a confession?
I just don't remember.
Okay, don't worry about it.
Yeah.
Can you?
I can tell you that he didn't try to. I don't know if I'm not sure it's relevant, but what I remember about the facts surrounding that were that he was in a period of deep emotional distress. It was the time when he was really decompensating at work. He could not cope with the emotional demands of a relationship. He could not cope with the resulting, having to live alone and then be moving back in with his mother. All of that was just overwhelming to him. This is not to excuse the homicide, but to provide some context for it. Many people have difficulty with these kinds of challenges, but most people aren't coping with those kinds of challenges with a significant intellectual deficit, which causes the coping mechanisms to be non-existent, essentially. Right after the homicide, he didn't run away or anything. He was just sort of waiting to be apprehended. It was a crime and a tragedy. But his history of having grown up amidst violence, amidst total emotional, physical, environmental chaos provides a very important context for understanding why the way he decompensated involved a homicide.
One of the things I read in the mitigation testimony was that when he told his mother that the woman had broken up with him, that she put her arms around him and he wept for a full hour. Do you feel comfortable talking about that? Or?
Sure. I believe one of the recollections that family members had was that when Warren told his mother that he had broken up with his girlfriend, who was the victim of the homicide, that she held him in her arms as he wept for an hour straight. And it was around this time that they would find him in his apartment, buried under blankets and non-responsive. He had a reoccurrence of his seizures at that time. The family took him to Naval Hospital to be evaluated. the examining physician at that time recognized that he had an intellectual deficit, in addition to the seizure disorder. So Warren was coping with a lot,
And can you just
or not coping.
can you just clarify the sequence that he started having seizures again before killing the girlfriend?
I believe that's right. Yeah.
Yeah, that's
So
right.
he started to have problems on the job, as we've talked about, and at the same time he started having more frequent seizures, more severe seizures, and that in turn was impairing his work functioning as well, and that was before the events leading up to the first homicide.
Was he ever treated for the seizures?
I believe he was seen by he was examined at a naval hospital in Jacksonville. I believe he was diagnosed with seizure disorder, and I believe he might have been on some medication at the time afterwards.
And didn't they say that after one of the seizures he was disoriented for days?
Yes, the seizures could often be followed by periods of disorientation and personality change.
Do you know how old he was when he committed the first homicide, and why did he not get the death penalty?
I believe he was 25 when the first homicide occurred. Why was he not charged with capital murder? I think that this was a shooting. It was quick. Death was instant. It may have been that the prosecutors didn't see enough aggravating circumstances under the statute to charge him with capital murder. That is pure speculation.
And she broke up with him, or
That's correct.
can you just say that?
She broke up with Warren. She broke up with Warren.
Thank you. So now if we come to the, could you say how many years he'd been in prison when he committed the other homicide, and that he had, my understanding is, again, a spotless record?
Mm-hmm. He was sentenced in 1986 and had been in prison, I want to say 4 years before the homicide occurred in prison. Now, during that time, he had a spotless record in terms of disciplinary proceedings. He didn't have any problems. However, the records do clearly show that as his security classification was ratcheted down, he began to, and his living conditions were altered such that he was in close proximity in an open dormitory to dozens of other prisoners, that he began to have trouble. And by trouble, I don't mean disciplinary trouble. I mean that he seemed troubled to the counselors, that they were concerned that he was being victimized or had the potential to be victimized by other inmates. He seemed under stress, and I believe he had asked to be moved away from this particular inmate. In the counseling sessions, he had a great difficulty expressing his mental state, expressing any feelings. He would be asked, is anything wrong? Are you okay? And he would simply respond very curtly, I'm fine, I don't have any problems. So he was unable. We know that he was being harassed. We know that he was experiencing some significant stress in the new environment, but he was unable to utilize the available, resources to try and deal with that in a productive way. And that is consistent with intellectual disability. That is an adaptive skill deficit. And the prison records were just rife with that kind of. The prison staff were concerned for Warren. And eventually, the homicide did occur in the dorm setting.
Now, when I read the trial transcript, I was sort of mystified about what had the guy that he killed, the prisoner that he killed, what is it he was sweating on him? And then later, I understood that he may have, that Mr. Handspike, which sounds like it's straight out of Dickens' name, doesn't it? That he was having sex with another guy, and that he may have made sexual advances to Warren. Is that right? If you could talk about that.
My understanding is that the harassment towards Warren did have sort of sexual overtones. And, I think that regardless of the sort of content of the harassment, any sort of harassment like that would have been something that Warren would have tried to get away from. It would have been extremely stressful. And I think it was. And many inmates testified later on when we presented our evidence that, in fact, this was happening on a regular basis, and that at one point Mr. Handspike had shown Warren weapons that he had fashioned. So there was a clear threat of physical harm that was being directed at Warren.
So, I don't know if I even want to ask you to describe that actual killing. It was so awful.
I really don't want to describe it.
Joe,
It's in the record.
It's pretty horrible.
It's in the record, and it's yeah.
Okay, but could you address the fact that there were all these witnesses, all these other inmates when Warren went after Handspike, and one of my questions was that it said in the transcript the correctional officer left and went to phone for help. Why didn't he say, "Stop it, I've got a gun"?
Yeah, first of all, they were not. Prison staff are not armed.
Oh, okay. So he didn't want to go.
That's
in
probably
there and
the
try and
answer to your
stop it.
question.
Okay, all right. So, and
But
Joe, I know I talked over him, but that's okay.
But Handspike was alive after the assault, and the ambulance took 30 to 45 minutes to get there.
So it wouldn't have been a murder.
Well, maybe it would have been, but we'll never know because there was no rapid response. And I hate to say that's probably typical of the way injured prisoners are treated, but it almost certainly is and was. But I can't believe that he wouldn't have benefited from some rapid medical treatment, which he didn't get.
Injured black
Yeah.
prisoners. So I wondered, why didn't the defense at trial call a medical doctor to testify about Warren's seizures? Because that kept jumping out at me. I wondered if the two homicides were temporal lobe seizures.
I don't remember that. I don't remember how we might have. I think we just sort of generally alleged that they did not. The trial attorneys did not have the. They did not do a thorough investigation that would have uncovered that kind of information. That they may have had. I can't remember. They may have had the records, but they didn't use them or they didn't get the records. I don't remember exactly.
Could you just repeat a bit of that and say it was about the seizures, the history of seizures?
Which part?
Just that the defense at
Uh-huh.
trial didn't bring in evidence of
Okay,
seizures.
so and you're gonna have to double check that for me because
They didn't.
They didn't, okay.
bring it in, that's why I had the question.
Uh,
That's why I was so grateful to you for sending the
Sure.
transcript. Yeah.
So the trial attorneys did not or weren't able to uncover and present to the jury evidence of Warren's history of seizures. So the jury did not know about that. The jury did not know about the history of the severe history of abuse and neglect and trauma that Warren had experienced growing up. They did not know that he had shown clear signs of intellectual deficits in the early childhood period, all of which would have certainly improved his chances of getting a life sentence.
So did anyone ever argue at any point in all the appeals, I didn't see it, that those killings could have been temporal lobe seizures? I didn't see that any of even your experts suggested that, but I know of cases where the only acts of violence were, this was in a kid and not killings, but turned out to be temporal lobe seizures.
I believe that our experts did, at least one of our experts did address the possibility that the seizures, that there may have been, that the seizures had an impact on his functioning, but not necessarily at the time of the crimes. I don't think we could substantiate that. And it's really not something if you don't really have the evidence for it, you don't put it out there as robustly as you might otherwise. The main issue we definitely felt that we had the goods on was intellectual disability.
And I will come to that in a minute. At trial, the prosecutor in his opening said to the jury, Warren Hill was not slow. And I'm yelling as I'm reading this, how did that get by? Why was he allowed to say that? And I understand why he said it, and what were the consequences of his saying that?
Well, I think that this again points to here the defense did not. It's important to recognize the defense did not raise a formal defense of intellectual disability. They did try to put on what evidence they had that suggested that Warren had limited intellectual functioning, but they didn't go so far as to mount a formal defense because they just didn't feel they had the evidence for it. But they did try and put on evidence that Warren had a limitation, whether you want to call it intellectual disability or something less severe. He did have a limitation. And I believe there was family testimony that he was slow. So they put on that kind of testimony. Again, very superficial and barely scratching the surface of the reality. But arguments like he's not slow are typical in cases by the prosecution, are typical in these kinds of cases because, of course, the prosecution has the right and the opportunity to argue in rebuttal to this kind of evidence. They can point to superficial behaviors or activities of the defendant that seem to point away from some kind of intellectual limitation. And this brings up the issue of the stereotyping that goes on about people with intellectual disabilities. So, for example, it was enough to say that Warren had a job of any kind, or that he could drive a car, or had a girlfriend, that to instill that reasonable doubt, or to instill any doubt, that Warren had an intellectual deficit. And this, of course, was our challenge throughout the litigation of his case, was trying to, we were confronting at all times these stereotypes about people, especially like Warren, with what was called mild intellectual disability. That word mild is very misleading because that's the intellectual disability has sort of three levels of severity: mild, moderate, and severe. People's image of society's image of people with intellectual disability tends to focus on what would probably be more accurately called severe intellectual disability, people who are virtually non-functional. But most people with intellectual disability have mild intellectual disability, and they tend to be harder to, it tends to be much more difficult for lay people to see that someone has an intellectual disability if they have mild intellectual disability, because they don't have physical features that, make them look different from people without intellectual disability. They can often do things like have a job. They can have a family. They can drive cars, have a driver's license. They can achieve academic functioning up to the equivalent of someone who's 11 years old, say, in 5th, 6th grade. And 5th and 6th graders can often read, write, and do things competently, such that you wouldn't label that kind of activity as consistent with intellectual disability. So it tends to be masked. The deficits in emotional regulation, the deficits in key practical skills around self-care, home living, those things can often be masked by receiving the person with intellectual disability may receive assistance from family members that you don't see. They may have other supports that are, someone comes and picks up the person in their car and takes them to work so they can carry on and have a job. People with intellectual disability have strengths and weaknesses. So they can have strengths in various areas, but weaknesses in others. And the diagnosis is made by looking at the weaknesses, not the strengths. So you don't say as a clinician, and you shouldn't say as a judicial decision maker, that just because someone can drive a car or have a family or have a job, that they can't have intellectual disability. You have to look at the weaknesses. So if this person has the low intellectual functioning, and this person has weaknesses in certain areas, then that qualifies as a diagnosis. And the reason why you in the clinical setting you only need to show like 1 out of 3 or weaknesses in like 1 out of 3 skill areas is because those weaknesses are so severe, or tend to be so severe, that when a person with intellectual disability confronts a difficult life challenge, the weaknesses can cause total decompensation. Whereas for someone without a disability facing an extremely difficult life challenge, they are more able to sort of deal with it robustly because they don't have those kinds of severe weaknesses. So it's those weaknesses that can cause the problems for people with intellectual disability.
Great. And can you address the phenomenon of how Georgia's such a high burden, the beyond a reasonable doubt burden of proof, how did that interact with the prosecution's, I thought, quite disingenuous claim that, well, he had a job or he was in the Navy, as though that proved that he didn't have an intellectual disability? I thought if the jury didn't know.
Well, let me clarify that a defense of intellectual disability was not raised at trial. So they didn't have the burden of proof to contend with. They were simply putting on mitigating evidence at sentencing that suggested that he had a limited intellectual functioning. However, when my firm, my office, took the case, we did raise a claim of intellectual disability, and we had to prove it beyond a reasonable doubt. And so the burden of proof was our challenge to overcome with our judge, and we had to deal with those arguments that you're describing from the Attorney General, which was our opponent in the case. So the Attorney General would make the argument that, and our judge also succumbed to stereotypes about Warren, where his work with the Navy, his having had a girlfriend, having been able to drive a car, all became justifications for finding that he could not surmount the reasonable doubt standard. When we had, clearly documented severe deficits in interpersonal relations, emotional regulation, those kinds of things, and we had been able to show that where he seemed to have strengths, he had been getting assistance and support from others, so that those were not really evidence of strengths. Those were masked deficits. He had written letters to his attorneys, very poorly written letters, but he had written letters, so that was used against him because people with intellectual disability can't write. That's another myth. If you can imagine, your 11-year-old writing a competent letter to someone, that's the kind of letter we're talking about. So people with mild intellectual disability like Warren Hill are not the sort of non-functional people that for the stereotype conjures up. They can function in daily life with help, and they need extra help when they're dealing with intense challenges in life. So when a girlfriend breaks up, you're having trouble at work, you're having trouble taking care of yourself at home, all of those challenges are kind of snowballing on you. It's hard enough for someone, a 25-year-old with normal intelligence, normal functioning, to cope with, but it is potentially a disaster for someone with an intellectual disability who doesn't have the right kind of support.
Oh, you're so fabulous. This is wonderful. Thank you. The jury at trial asked to see the psychologist's report, and it seems the judge denied it.
I don't recall that they wanted to see the psychologist's report. I believe they wanted to see the test scores. I recollect very clearly that the jury wanted to see, the jury may have even sent a note out asking for test scores.
I thought it was the psychologist.
But you can double check me on that. I don't remember, but I know that they wanted to see the test scores, and they may have sent a note out to the judge about that. They would have been told, you just have to look at the evidence as you've received it. They wouldn't have been told they wouldn't have been given any explanation about why they were or were not seeing test scores. That may have also come to light when I believe there were post-trial juror interviews conducted by the defense, or there were questionnaires given to jurors by the defense after the trial in which they said, where were the test scores? one of the jurors was someone who had experience with with teaching or education, and so was expecting to see test scores. And when they didn't, there was a concern that those were being withheld from them by the defense, which worked against Warren. And then again, this is at the trial. One of the things we did, as I've discussed in our at the time of our representation, was to bring in those scores as part of our claim that the attorneys had failed to do that. The judge's conclusion in our post-conviction case ultimately was that the attorneys had done their best with the resources and time they had. So there is an element in this case of the court itself being so parsimonious that it rendered the attorneys ineffective. But it's the bar, the standard for measuring attorneys' performance at a trial is so low that you can have subpar performance that doesn't necessarily get found constitutionally ineffective. Here, the test scores, for example, were not available to the jury because the attorneys didn't get them, but the attorneys couldn't go to the schools like we did and interact personally with the records custodians because the court wouldn't fund any travel, So all of those things were working against Warren at that time.
So the court doesn't allow defense counsel to do their job properly, and then the court finds that, because we didn't give them adequate resources, they were performing adequately. They weren't ineffective counsel. Is that what you're saying?
More or less.
Yeah.
That's essentially the conclusion, is that they did try. They did put on some evidence. So we're going to give them a pass. But the fact remains that critical evidence was, not presented to the jury, which could have resulted in a robust defense of intellectual disability, or at sentencing, mitigating evidence that could have convinced the jury to go for life. And several jurors did indicate to us that they would have voted for a life sentence had they been apprised of this information. I think we received testimony from about 4 of the 12 that they would have voted for life.
Were blacks excluded from the jury?
They probably were, but there were several. There were at least 2, possibly 3 African Americans on the jury.
Okay. I'm going to get to the test scores finally now. And let's see. I don't know I'm trying to think how to do this efficiently. My understanding, please correct me if I'm wrong, is that finally in 1999 he had his first IQ test.
I'm just going to
Sure.
do some
I
adjustments.
believe it was 1997.
97?
Mhm.
Okay, and then he got a full-scale IQ of 77.
He got a.
Hang on,
Oh,
where's
sorry.
my,
Sure.
second?
And I want to take a bathroom break in a minute, okay? Yeah.
Okay.
Well, let me just read to you what I've got here. And
Sure.
I maybe, so I had Dr. Dickinson in
Mhm.
99. I had maybe it was a
No.
typo. Gave him a WACE R,
Mhm.
and gave him a
WACE
WACE
R.
R, and he got a full scale IQ of 77, which I thought, oh boy, that's going to be hard to deal with. And
Right.
then Dr. Toomer tested him in 2000 using the WACE 3.
Mhm.
And that his full scale IQ was 69.
Right. Well, it's incorrect that he got the WACE-R in 99 because that's after his trial. Dickinson was the trial psychologist, so that test score would have been obtained in 1991 or thereabouts. And that, I'll talk more about that test in a minute. Then he was administered Stanford-Binet in 1997 by Dr. Daniel Grant, and he received a score of, I believe, 71. And then in 2000, the WAIS-3 with a score of 69. So the WAIS and the Stanford-Binet are considered the gold standard tests. What happened with Dr. Dickinson was that he had a grad student administer his WAIS. Now, that was the WAIS-R. And the test that was given in 2000 was the WAIS-3. That was the next iteration of the test. So on the WAIS-R that was given in 1991 by Dickinson's grad student, there were several scoring errors that we uncovered in our investigation, which probably reduced the full scale by a few points. In addition, because the WAIS-R was fairly, the data on which the WAIS-R was normed was getting old at that time. And what tends to happen as a result of that is that the IQ score gets inflated a little bit. It's called the Flynn effect, named after the person who discovered this phenomenon. And what's happening there is, hope I get this right. What's happening there is that the population as a whole tends to get more knowledgeable and some people say smarter over time because they're inhaling a lot more information from the ambient sort of environment, television, whatever, the media. And so as a result, the people on whose scores the test was normed, they got that data, maybe a decade previously, and so when you measure someone's score taking the test many years later, that person that person may test in such a way that I'm not explaining this right. If you were to measure that person's score against the current population, the score would be lower because it would be the baseline for everyone would be a little higher. But as compared with this earlier population, the score tends to be inflated a little bit. It's like 3 points a decade, or 0.3 points every 3 years. And so with all of that interacting, the scoring errors and the Flynn effect, that score was still fairly consistent with a mild IQ, mild intellectual disability diagnosis. And the WAIS-3 and the Stanford-Binet, those tests were given at a time when the normative data of those tests was much more aligned with contemporary times. So his scores were more accurately reflected in those results. And they are consistent with the early life test scores, which were not IQ tests, but were in the second, third, and third percentiles nationally, which is an equivalent essentially to a mild ID IQ score if you're diagnosing the syndrome.
I'm a psychologist. That was the best description of the Flynn effect I've ever. I'm trying to remember when the WAIS-R.
The WAIS-R came out in the 80s. It may have been 80. I think it's easy to find out.
So yeah.
So the normative data would have been a decade old. You're talking about 3 points, roughly.
And then if you add in the scoring errors from the grads,
then you're getting an
much
IQ
closer
score
to
around
70.
73,
Yeah.
and the that's plus or minus 5 points either way, and so you're within the strike zone. But again, what having an IQ of approximately 70 means that it's just, it may be a matter of opinion for different experts as to whether you're falling on the side of intellectual disability or borderline intellectual functioning. So it's, that gives rise to doubt, right? If your test is reasonable doubt, having one expert out of 4 say, I think he's really a borderline intellectual functioning candidate, means that you lose your ID claim. In this case, we had Dr. Dickinson, Dr. Grant, Dr. Toomer all agreeing that the IQ scores, in conjunction with the clear evidence of adaptive skill deficits and cognitive impairment throughout the developmental period, was absolutely consistent with an intellectual disability. One of the tragedies of the trial was that Dickinson, at that time, this is the psychologist, didn't understand that he'd made scoring errors and was wondering why there wasn't any testing in the school records himself. In fact, I believe he testified that he wondered where that testing was. And one of the reasons why he could not, at that time, make a diagnosis of intellectual disability was that he didn't have the test scores to verify. So had he had those scores, the 77 IQ probably wouldn't have deterred him from making a formal diagnosis. But as it happened, he recognized that there were scoring errors in his testing and that there were other reasons to believe that the score had been somewhat inflated. He agreed with our evaluators later on, of course, that Warren did have an intellectual disability. So we went into our court proceedings armed with substantial evidence of intellectual deficits and adaptive skill impairments throughout the developmental period, through adulthood, up to the time of these homicides and beyond.
I have to take a quick break
Sure.
in the bathroom. Okay.
It's right down the hall on the right.
All right, you ready?
I'm all set, yeah.
Is my computer going to be in the way?
Nope.
Okay, because this didn't print out clearly. So we will get to that. Could you comment about the fact that the state called in okay. So why don't we start with how you became involved in Warren's case?
So I came to work after law school in 1996. I came to the Georgia Resource Center here in Atlanta, which is a nonprofit law office that provides representation for free to indigent prisoners sentenced to death in Georgia. The Resource Center covers the whole state, monitors all the death penalty cases in Georgia, and makes sure that they have counsel once they've completed their first round of direct appeal and enter what is called habeas corpus proceedings. Habeas corpus is a civil proceeding where these prisoners can contest the fairness and constitutionality of the trial proceeding, usually by, for example, alleging that their trial attorneys, performed ineffectively under the Sixth Amendment by failing to investigate and present evidence of mitigating factors, intellectual disability, that sort of thing. And that is why we reinvestigated Warren's case. His was the first case I was assigned to in 1996, so he was the first client I met. And so we commenced investigating his case from the ground up, his family background, his educational background, his work background, everything. And it was clear from the beginning that this was a person with intellectual impairment and probably intellectual disability. And so we geared a lot of our investigation towards trying to see whether we could substantiate that. We talked to many family members. We talked to as many teachers as we could find, all of whom were consistent in saying, again, that Warren was intellectually disabled. They had no doubt about that. We had him evaluated by psychologists, one in 1997, the other in 2000, as we were preparing for our evidentiary hearing in the case. And those evaluations and testing results were right in line with intellectual disability. The defense psychologist from the trial period was called again as a witness to review all of this material, and he agreed that it was all consistent with intellectual disability. So we formally raised a claim of intellectual disability. We were compelled to prove intellectual disability beyond a reasonable doubt. And when we went into our evidence, so the state in turn had a psychiatrist and a psychologist evaluate Warren, and they essentially did not dispute the diagnosis, other than to sort of fall on the side of borderline intellectual functioning, which is if you're talking about an IQ of approximately 70, a diagnosis of borderline intellectual functioning can be found where you've got an IQ of between 70 and 85, roughly. So with an IQ of approximately 70, a doctor can find that borderline intellectual functioning is perhaps the proper diagnosis. But again, the dispute is very fine here. It is right on the cusp. The state evaluations were extremely rushed right before the evidentiary hearing. There was a sense that they had barely reviewed any of the background materials that we had provided them. That included massive amounts of documents. It included affidavits from family members, reports of our evaluating experts. They were turning this stuff around in a couple of days, essentially. These doctors seemed to have very archaic notions of what intellectual disability was. They engaged in stereotyping, as we've discussed, that I frankly found shocking for people who called themselves, medical doctors and psychologists and psychiatrists. But, for example, the psychiatrist that was presented by the state felt that because Warren did not present as the character Benny on L.A. Law, who was an intellectually disabled character with obvious sort of behavioral and physical markers that people associate with intellectual disability, that he was not intellectually disabled. The fact that he had jobs, a girlfriend, had driven a car, all of those things. In other words, they made the mistake of relying on Warren's apparent strengths to rule out intellectual disability. Now, they didn't say Warren has normal functioning. What they said was he's right on the borderline side of the intellectual disability diagnosis. He's right on the other side, based on that IQ score. So for that reason, our judge found under the reasonable doubt standard that we couldn't prove intellectual disability beyond a reasonable doubt.
I just have a question about that. I was really shocked as a psychologist to see that of the state's 3 expert witnesses, only one was a psychologist, and the other two, if you're not a psychologist, you haven't been trained to give an IQ test.
Right. Well, the other two were psychiatrists. Well, one was a neurologist, I think, and one was a psychiatrist.
So if you could just start with the state's expert.
Of the state's expert witnesses, only one was a psychologist who was trained to administer intellectual functioning tests or to interpret them. The other two were a neurologist and a psychiatrist, both of whom are MDs, not psychologists, not trained in administering tests. So they had to rely on the psychologist's conclusions. The psychologist, I believe, he didn't dispute, the IQ was not in dispute. That was clear. All the doctors had no dispute with the IQ score that our experts had obtained. In other words, there was unanimous agreement that Warren Hill had an IQ of approximately 70. That is an extremely low IQ. It's called significantly sub-average intellectual functioning, and it meets the IQ prong of the diagnosis. Where the dispute fell was on the meaning of Warren's adaptive skills and what his history showed. So where the state doctors focused on apparent strengths, our experts correctly focused on the weaknesses, and they also saw through some of the apparent strengths to see that sometimes those strengths were actually only because he was receiving support, so that it looked like a strength, but was in fact an instance of a weakness being propped up. The state doctors didn't engage in that level of scrutiny or nuance, and as a result, neither did our judge. But this is a situation where, in fact, we challenged, again, the burden of proof in the case, and our judge acknowledged in a written order that were the burden of proof not reasonable doubt, but preponderance, he would find Warren to have intellectual disability and therefore be exempt from execution. But because the law says beyond a reasonable doubt, he was unwilling to find that we could prove it. Now, I disagreed with that. I believe that a correct clinical interpretation of the evidence, supports a finding of intellectual disability beyond a reasonable doubt. And I think that the U.S. Supreme Court has recently issued decisions that essentially agree that you've got to conform to correct clinical standards in diagnosing intellectual disability. And they have explicitly said you look at the weaknesses, not the strengths. That didn't happen here, and that's a mistake that was made by the state's experts and the judge in this case, which was Warren's downfall. Later on, Warren became eligible for an execution warrant. We had several stays over the course of about 3 or 4 years in Warren's case, where we were able to stop scheduled executions of Warren, based on a couple of occasions a lethal injection matter. But in one crucial instance, it was because those same state doctors, having taken more time to review the evidence and having also gotten more experience under their belts as to how to diagnose intellectual disability, they came to agree that Warren did have an intellectual disability. And so by 2013, we had unanimous agreement among all of the experts who had evaluated Warren that he was intellectually disabled.
That's great. Can you just, I want to focus on the moment when the phone rang and it was Dr. is it Sachi?
Dr. Sachi.
Yeah. Okay. Could you just
So we
describe
had
that?
sure we had stopped Warren's scheduled execution the first time an execution warrant had issued, based on, I believe, a lethal injection matter or a challenge to the lethal injection protocol, and it was an indefinite stay. There had been a lot of media attention around the intellectual disability issue, and as a result of that, I was contacted by one of those doctors, Dr. Sachi, the neurologist, who acknowledged to me that he thought he had been wrong in his diagnosis, and that, was there anything he could do? And so at that point, I said, yes, I swallowed my frustration and anger towards him and said, yes, you can take a look again at this material. And one of the things he acknowledged to me was that he'd barely had a chance to review it in the first place. That this was an incredibly rushed evaluation, that it had happened at the last minute before the hearing. So it was not the product of careful deliberation over the available evidence. So this time we took the opportunity to have him do that. And he also acknowledged that he was kind of a brand new or an inexperienced doctor at that time, and so didn't have the knowledge and experience level to understand the diagnosis properly, or understand how to interpret the evidence in light of the diagnosis, the diagnostic criteria. So he agreed that the evidence clearly showed intellectual disability and that he'd been mistaken previously. When he signed an affidavit to that effect, I then showed that, along with binders of materials, to the other doctors who had been involved in the case. They concurred that it had been an incredibly rushed operation, and that in hindsight, and based on the available evidence, which they had now had an opportunity to review more carefully, it appeared that Warren was indeed intellectually disabled. And so we now had unanimous agreement. And when another execution warrant was eventually signed, we were able to get that execution stayed for a time. The problem was that the rules of habeas corpus procedure privilege finality over and form over substance. And so our courts could not find a legal avenue available to, at this late stage, give effect to this new evidentiary posture of the case. So even though the law forbids, the federal and state constitutions forbid the execution of people who are intellectually disabled, even though we had all, I want to say, 7 doctors who had evaluated Warren agreeing that he was intellectually disabled, it was too bad, because it was all just too late and nothing could be done legally. And he was ultimately executed.
So how many appeals were there, and on what grounds?
There were at least a half a dozen appellate actions, especially under execution warrant. We will go back to state and federal courts to try and obtain stays of execution. And we did that in Warren's case. I think there were 3 warrants, so we did that several times. Because at that time, so we were getting this new evidence. Also, there were changes in the law coming down from the U.S. Supreme Court. They were expanding on their 2002 decision in Atkins v. Virginia. They had decided in Hall versus Florida around this time that, state courts had to adhere to clinical standards in evaluating claims of intellectual disability. This is exactly what had not been done in Warren's case. And so we tried to leverage that new law. But again, the rules state essentially that you can't apply these new cases to, cases like Warren's where he'd already been through the court process. So these are very technical rules designed to discourage appeals. So unfortunately, even when new evidence of this kind, or even let's say exonerating evidence, exculpatory evidence, it's very, very difficult, if not impossible, to get courts to even consider it. So in the end, courts did not even consider this new evidence. They decided they couldn't consider it, and so the claim failed. But the tragedy of it is that Georgia was the first state to outlaw the execution of people with intellectual disability in 1988 as a direct result of the popular outcry against the execution of Jerome Bowden, who had an IQ in the 60s. This law was enacted as a direct result, and yet we are still in Georgia going to execute. We have executed and are going to continue to execute people with intellectual disability because of the high burden of proof and the refusal to give effect to the notion of miscarriage of justice in order to examine new evidence that may show that someone is intellectually disabled, where before they might not have been able to. So that is a real shame.
And my understanding, just in lay people's terms, if you could just say a sentence, is that despite all of this unanimous evidence now, that the courts refused to hear the evidence because they said the issue of intellectual disability had already been litigated?
It had already been litigated, and
So if you could just
right.
Yeah.
So the court said that they could not consider this new evidence because the issue of intellectual disability had already been litigated, and there were no available mechanisms to reopen the prior proceedings to allow the new evidence to be considered.
And in what courts was that determined? I know you tried to get
It was determined in all state and federal courts.
And could you say a sentence or two about trying to get the U.S. Supreme Court to grant cert?
We tried on several occasions to get the U.S. Supreme Court to grant cert on this issue, and we could not budge them. Again, the problem, the basic problem was that the intellectual disability claim hadn't been raised at the time of trial. It was raised in post-conviction when there are rules about, when and how you can raise those claims so as to be cognizable in the various courts. And of course, the reason why it wasn't raised properly at the trial court was because the attorneys just didn't have the wherewithal to do it.
So, at what point in all of your involvement was the 2002 Atkins decision handed down, and did that have any positive impact on what you were doing?
Temporarily.
If you could just incorporate the question.
Sure.
Yeah.
The 2002 decision in Atkins versus Virginia had a temporary effect on our case that was positive, in that it came down as our post-conviction court was deliberating on Warren's case, and what we said was, now that there is a federal Eighth Amendment-based ban on the execution of people with intellectual disability, that should mean that the burden of proof in Georgia should fail, that it should be replaced with a standard that does not burden that right unduly. So the argument there was the beyond a reasonable doubt standard tends to cause people who are more than likely intellectually disabled to be exposed to wrongful execution. And there is ample precedent for not burdening rights that are enshrined in the Bill of Rights, i.e., the right to not be subject to cruel and unusual punishment, to undue burdens of proof. So, for example, to prove that you are not competent to stand trial beyond a reasonable doubt would cause the problem of people who are more than likely incompetent to stand trial having to stand trial. So we made that argument. That argument failed in the state court. I take that back. That argument actually succeeded before our judge. Our judge determined that the beyond a reasonable doubt standard was unconstitutional, imposed a preponderance standard, and remanded Warren's case to a jury. This was in the state court in the early 2000s, after Atkins was decided. Now, that decision was appealed to the Georgia Supreme Court, which reversed. So then we went into federal post-conviction proceedings. And again, we challenged the Supreme Court's decision finding that the beyond a reasonable doubt burden of proof was constitutional. And we made the same argument under Atkins. The first, the district court denied that claim, but the federal appellate court initially agreed with us and reversed the district court, finding that the burden of proof in Georgia was unconstitutional, and sending it back for further proceedings in federal district court. But the state asked for reconsideration by the full 11th Circuit Federal Court of Appeals. That was granted. The initial decision was reversed, and the burden of proof in Georgia was reinstated, and Warren was out of luck at that point. We took that up to the Supreme Court. That they didn't grant cert.
They don't have to say why they're not granting
No.
cert. They just say no. On what grounds were these courts at different levels saying that the beyond a reasonable doubt standard is constitutional?
The rationale of the Georgia Supreme Court was Atkins says we can do whatever we want in terms of the procedures by which we determine who is intellectually disabled. And therefore, under federal habeas law, while it may have been incorrect to say that Georgia had unlimited latitude, it was not necessarily unreasonable given some language in the Atkins decision, which could have been construed to grant that latitude. Now, that's not to say that our federal court decision makers agreed that was a correct interpretation of Atkins, but under federal habeas law, the state court has to have made an unreasonably wrong decision such that no jurist of reason would agree with it. And that was the problem in the federal courts.
Now, you very beautifully talked about the irony of Georgia being the first state to outlaw these executions. Now, how do you think, or why do you think it came about that Georgia, having been a pioneer, then has the highest burden of proof of any state in the country?
I think that Georgia, as a pioneer in this area, didn't think it through. They placed the legislators placed the burden of proof in a weird place in the statute. This is the statute that says that talks about, what are the consequences of different kinds of verdicts that juries can return in the guilt-innocence phase of a trial. So it includes provisions such as if the jury finds the defendant not guilty by reason of insanity, the defendant shall be remanded to the custody of a mental health facility, and so forth. So they put it in there so that it says if the jury finds the defendant guilty but intellectually disabled beyond a reasonable doubt, et cetera, et cetera. So the burden, the intellectual disability defense actually has to be presented at the guilt-innocence stage of the trial, and the verdict comes out as guilty but intellectually disabled beyond a reasonable doubt. So it kind of conflated a defense against capital punishment with the guilt-innocence phase verdict, and I think there was some confusion about that in the first place, or a lack of foresight into how that would play out. But in practice, it just makes this burden, it makes the protections virtually non-existent for people with intellectual disability. In fact, no one in the past 30 years has been sentenced to has gotten a verdict of guilty but intellectually disabled from a jury for malice murder in Georgia. And we have executed recently several people with who are more than likely intellectually disabled. Warren Hill being the most egregious example, but not the only example of people with IQs in the of 70 or so being executed in Georgia. So the statute is not doing its job in Georgia.
If somebody were found,
I'm going to ask you just to pause. I'm sorry.
Sure.
It's changing.
okay, the question's going to be, if somebody were found to be guilty but to have an intellectual disability, would that presumably bring a lighter sentence?
It exempts them from. It precludes a sentencing phase. They're not eligible for the death penalty at that point.
Okay, so but what would happen to that?
Sure.
I don't care if we don't get this one, but
So in Georgia, if a defendant is found guilty but intellectually disabled, then there is no sentence. This is in a capital case. Then there would be no sentencing phase because that person would have been rendered ineligible for the death penalty by virtue of being intellectually disabled, and they would then be sentenced to a life or life without parole term.
okay, so but
It
they
would
wouldn't-
revert to judge sentencing.
Okay, but they would never get like 20 years or so. It would be
No,
life or life without
that's
parole.
correct.
Okay.
Yeah.
All right, and let me just ask too. Well, did you ever use Daubert or Fry in any of the appeals?
There was no grounds to.
Yeah. Okay.
What we did later on under warrant challenge after Hall versus Florida came out, we did point out that our state court and the state doctors had all relied improperly on stereotypes and strengths, so apparent strengths as opposed to weaknesses in ruling out intellectual disability, and that was inconsistent with clinical standards. And Hall versus Florida commands that state courts must adhere to clinical standards in the diagnosis of intellectual disability. But again, that new precedent was not applied, and because we were just too late.
They should have lost their licenses for what they did. Let's see, we're getting close to the end. Did the Board of Pardons and Paroles, one of my favorite entities, give a reason for rejecting the petition?
No.
if you could just say that.
The Board of Pardons and Paroles gave no reason for rejecting any of the petitions for clemency that we sent them.
And just a couple of other questions. One is, do you think that the Hall v. Florida case is going to make a difference?
Yeah, it has made a difference. I think that Atkins and Hall, in combination with the advent of our capital public defender system, has prevented people with intellectual disability from being even exposed to capital trials, because the capital defenders are very good at quickly investigating and assembling evidence pointing to intellectual disability, and I think they've been fairly successful in convincing prosecutors that this person is almost certainly intellectually disabled. There's maybe we should just take death off the table, that sort of thing. I think it's been it's definitely been helpful in other jurisdictions in challenging bad determinations of no intellectual disability by state courts. I think it's been much more helpful probably in jurisdictions where the burden of proof is lower. But if you put someone with a valid claim of intellectual disability in front of a jury in a capital trial, I just don't think you're going to be able to overcome the burden of proof.
In Georgia.
Mm-hmm.
Do you think that? Okay, so that's even in spite of the Hall.
In spite of, yeah.
What is happening in other states? Well, two questions actually sort of related. One is, I assume there's still people on death row in Georgia with intellectual disabilities who were convicted before Atkins, or at least before Hall v.
So
Florida.
when anyone who was, here's what happened when the law was passed in 1988. There were maybe a dozen or more than a dozen men with colorable claims of intellectual disability who had been tried already prior to the law coming into effect. The Georgia Supreme Court found, I want to say 1 year later, that that category of prisoner should have the ability to avail themselves of the law if they had a colorable claim and had been tried before the enactment of the statute. So they made a special procedure whereby those prisoners, if they could make out a prima facie case, which would be a doctor's report saying this person has intellectual disability, for example, then they would be entitled to a jury trial on the issue of intellectual disability. So most of those prisoners have had their cases resolved as a result of that. Now, the standard of proof in that situation was not to be beyond a reasonable doubt, but because it was a remedial procedure, they imposed a preponderance of the evidence standard. And as a result, one of those men was found intellectually disabled by a preponderance of the evidence by a jury, and I think the rest have all negotiated life sentences, or almost all the rest.
But you think that?
But those who were tried after the enactment of the statute, they have their opportunity to present a intellectual disability defense, and what we've seen since then is failed defenses.
And how do you compare that to what's happening in other states? Are you familiar with?
Well, so Georgia was the first state to pass that ban, and then a handful of other states followed suit, but used lesser burdens of proof. So then after Atkins in 2002, most of the other states enacted legislation, or their courts, in the absence of legislation, crafted procedures to enforce the Atkins right not to be executed, or to adjudicate a claim of intellectual disability. And I would say that I think Atkins has probably saved dozens of lives, hundreds maybe, but but not in Georgia. I mean, in the other jurisdictions, it's almost universally a preponderance standard.
So, are you saying that since Atkins, people aren't getting executed anymore in other states if they have intellectual disability?
No, I think it's easier to prove in all other jurisdictions. Georgia's the only jurisdiction with this beyond a reasonable doubt burden of proof. So Georgia is not protecting defendants with intellectual disability. There are numerous examples of defendants with IQs in the 60s, low 70s, ample evidence of adaptive deficits, and being found not intellectually disabled and facing execution and being executed. Warren Hill, just again, one of the egregious examples. But in other states, it's not that it's easier to prove, it's that the burden of proof is more properly calibrated to ensure that people who are more than likely intellectually disabled are protected. And that is consistent with the Eighth Amendment of the Constitution, in my opinion.
But people are still being executed in other states, right?
Or sentenced to death, yeah, if their claims fail. But again, it's enough in Georgia for a prosecutor to say, look at this letter that this guy wrote to his mother. That should instill a little doubt, a reasonable doubt. That's all you need. And that's what's happening in Georgia. And that's enough. But in other jurisdictions, it's not enough for the prosecutor to say, well, there's a letter, or there's a job, or there's a driver's license. That's not enough to rule out a diagnosis of intellectual disability, and that's appropriate because that's in compliance with clinical standards. So.
Great. Just two other questions. The sort of the stereotypic idea among people on my side of the political spectrum, our side, is that black people get executed if they kill white people. But both of Warren's victims were black, right?
Hang on a second.
Yes.
Okay. So I just want you
Yeah,
to.
just give me 1 second. I'm just making some.
Yeah, right. But if you could mention that both of the victims were black, and then address the question: whether you think that racism played a role in any ways in his case? So.
Well.
Wait just a second.
Yep.
All right.
Yep.
Okay.
I don't know that it's not as simple to say black people who kill white people are going to get executed, whereas white people who kill black people aren't going to get executed. It's a little more complicated than that. The race of the victim is the key factor in whether someone is sentenced to death. So if the victim is white, the chances of being executed are the chances of the defendant being executed are far greater than if the victim is black. If the perpetrator is black and the victim is white, the chances of a death sentence go even higher. Here, Warren Hill was African American. His victims were African American. The jury that convicted him of the capital murder was 9 white jurors to 3 African American jurors. I don't recall the pattern of jury strikes. It wouldn't surprise me that the prosecutor sought to eliminate as many African American jurors as he thought he could get away with, because that is a common practice in our justice system.
And the last question I have is that, so you knew Warren for, did you say 19 years?
Yes.
And you went through all of that
Mm-hmm.
nightmare with him. Can you talk about where you were at the time of his execution and how that was for you?
I was at my office.
Let's start with
Oh,
that
sure.
time.
At the time of there were 3 execution warrants in Warren's case. We stayed 2 of them. The last one we could not stay. And on all of those occasions, I was in my office litigating up until the last minute. And I was, within minutes of his being executed, I was on the phone with him, telling him that, the last effort had failed, and apologizing.
Can you talk about what happened in that conversation? What he said?
As I recall, he was grateful for the work that had been done on his behalf, and not just by me, but by many other staff at the Georgia Resource Center over the years. And he, I think he just said something along the lines of, "I appreciate everything you've done," and that was about it.
I know that Georgia records the last words. Did he have any last words?
I don't believe he did, and it wouldn't surprise me that he did not have any last words.
And so, was he injected? Is that how they?
He is. All executions are carried out by lethal injection in Georgia since 2000.
Have you been involved in other death penalty cases since then?
Yes, I was the director of the Georgia Resource Center from 2009 to 2018, so dozens of capital cases.
How do you do that?
You have a supportive team who are all trained to deal with these cases and investigate them and litigate them. And it's something you are trained to do, and but it does take its toll. And Warren Hill's case probably took the greatest toll on me, just because I'd known him from the beginning of my legal career.
And what kind? Can you talk about the toll that it?
It takes an emotional toll, because your friend is being killed, and you can't do anything about it ultimately. And even though I thought I had, finally gotten there, we just couldn't pull it out, and that was deeply disappointing and horrifying to me. And it definitely it undercuts my faith in the ability of the justice system to achieve some semblance of fairness and respect for human decency. I think that it reveals that in Georgia, at least, the promise of the Atkins decision, the promise of Georgia's own efforts to protect people with intellectual disability was not fulfilled and is not fulfilled. And it's deeply cynical for the courts to reject even the most fulsome evidence of intellectual disability and to not enforce these protections. It's deeply, deeply disillusioning and disappointing. And I'm not someone who's who succumbs to illusions. So I have a realistic view, but even so, this was very hard to take. It was hard to see Warren in his coffin. It's hard to see his family distraught. So it was tough.
And so when you go through that kind of thing, then how do you go about trying to
You just get right back into the next case.
Do you think about him?
I think about him about every day, probably. And I miss him.
What do you miss about him?
His sort of, I knew that he was always there. And I could go see him. And he was always, he was bigger than me. I think there was almost a sense of, he's like an older brother that I had. One of his sisters at his funeral service said, "You all grew up together." And that was right.
In what way was he like an older brother?
Well, he would always, he was bigger. He was always kind. He asked after my health or how are you doing? How's life? Just sort of, he'd give me a arm around the shoulder on the way out. I don't know. Little aspects of his demeanor made me feel that way.
That's lovely. My last question is there any organized effort to get the law changed in Georgia to preponderance of the evidence?
There have been efforts, but as far as I know, they've all stalled out before they ever hit a committee.
Could you just say that again? Say what
Sure.
the efforts
There,
were?
Hang on, it's a siren
Oh,
going.
okay.
as far as organized efforts to overturn or replace the standard with something less onerous, I know that there have been some attempts by some groups to make that happen. There may have been a study undertaken by a legislative committee, but nothing has ever come to fruition.
Why?
I believe there is a misconception that a standard of proof that comports more with the requirements of the Constitution and which comports also with medical consensus is somehow too lenient or represents, makes it super easy to prove intellectual disability.
Is there something about Georgia that they don't get that, but all the other states do?
Well, Georgia, it's hard to change any law around the death penalty. Georgia is a conservative state. I would point out that Georgia was one of the top lynching states back in the late 19th and early 20th centuries. And we're a top executing state, even to this day. We are in the top 5 states that continue to carry out executions, even though the death penalty has declined as a sentence imposed in court and it's being carried out less and less. It is simply dwindling and falling out of favor all over the country, except for certain pockets of the Deep South, and this is one of them. And so it's part of the culture. It is a culture that does not respect the sanctity of life, no matter how much certain politicians may protest to the contrary. This is a state that has never cared for the poor who live here. It has been inadequate historically in dealing with systemic issues around poverty, mental health, those kinds of things. So education, services for people with intellectual disabilities. Things may have improved recently somewhat, but Georgia is trapped in a archaic culture of indifference to things that could make life better and probably prevent homicides from happening. And it is indifferent to the fact that it executes people with the cognitive functioning of an 11-year-old.
Thank you. This was just wonderful. I really appreciate it. And I know it's hard to talk about all of this stuff.
It is. This is a tough case. Kind of why I got out of doing it.
Yeah. I had some dealings with Thomas Dunn.
Oh yeah, he was my predecessor.
Yes, and I saw that he was involved in some of the proceedings.
Yeah, he was. He was my director for 10 years.
So we've been trying. We're through.
Yeah.
Yes, thank you.